Mr. Shima. Would ask counsel in 125685, State of Kansas versus Jose Garcia-Martinez to please come forward.
May it please the court, I'm Ryan Enninger, appearing on behalf of Jose Garcia-Martinez. With the court's permission, I would like to reserve 3 minutes for rebuttal, please. Thank you, Your Honor. Sedgwick County jury convicted Jose Garcia-Martinez of felony murder with the predicate felony of aggravated kidnapping. He was also convicted of aggravated battery along with a single count of simple battery. Mr. Garcia was then sentenced to life without the possibility of parole for 25 years. First issue that I've raised in this brief before the court this morning is that the evidence at trial was insufficient to prove both of the alternative means of taking and confining Mr. Hayden in this case in order to prove beyond a reasonable doubt that the aggravated kidnapping and therefore his felony murder, that conviction as well as his felony murder conviction should be reversed. I suppose the first thing I would like to address is I guess where I left off yesterday discussing the question of invited error. The state has raised that is as an issue here. Problem with this argument. I would submit that is not a problem here for the court today. This isn't a situation where the defense counsel somehow induced the trial court to make an error instructing the jury. In fact, I haven't argued that there's any actual problem with the instruction in and of itself. I've just argued that the issue here is that there was insufficient evidence to prove both alternative means of the offense of aggravated kidnapping. I know this court had stated in State v. Haberling that taking and confining are alternative means.
Why don't we start right there? Were we right about that?
I think absolutely so.
And how is it that it just strikes me when you look at taking or confining that fits better with the options within a means rather than alternative means? And how do you confine without taking?
I think I can imagine a situation where someone is in a room and let's say if I'm the actor, I walk up, shut the door, screw the door shut. I haven't taken you, I haven't removed you, I've just now confined you. So I think that is one distinct way that those two things could be different. And I think, you know, when we look at the statute, the intent to hold is the part that comes thereafter. The statute is written saying that aggravated kidnapping is, and then it states, and then if we say that taking and confining are not alternative means of committing the offense, then what are we left with? There's no actus reus, there's no guilty act any longer. If it sort of renders everything, and I think that's where Judge Malone erred in his analysis of this, was he sort of removed any act. Basically, he relied on the intent element of intent to hold as being the act. And I don't think that's the correct interpretation or construction of the statute.
What is the actus reus?
It would be to take or to confine.
Okay, so give me an example of kidnapping with just taking.
So just taking, that's more difficult to parse, obviously. I think it's a situation of just taking without confining. Is that what you're asking? Or confining?
Well, if you're saying that it's the intent to hold a person, which is basically confining, that's not the actus reus, then you read the statute is kidnapping is taking a person by force, threat, or deception for ransom, to facilitate fight, to inflict bodily injury. Taking. How is, I don't really understand how you can have a kidnapping with just taking.
I think the taking would occur similar to a situation, I suppose, in Lloyd, where somebody's being, you're in a public area. The fact pattern there was a situation that was argued, and I think that would be a situation where that's a taking without a confining. Confining, I think, has to denote some sort of physical boundary. And that's the distinction there. I think a taking would be something where somebody is being removed, and in Lloyd, I think it was the defendant was his spouse had come there through, he was going to be arrested for probation or something. The evidence of it was that then they left sort of, it seemed as though it was maybe voluntary, but he was in some way holding her. So he had apparently removed her from the house in some way and was walking down the street with her. I would argue that in that factual circumstance, that's taking, but he wasn't necessarily in that circumstance confining to an area. I think
Well,
that
wasn't he confining her to the area within
Presence,
which he
I-
was, his
but
presence?
in presence, I guess that would
Right.
make sense. But I think that there's definitely, the legislature didn't write that with just taking and confining meaning the same thing in all circumstances. Now, there can be, and it will be, I think, frequent that both things will exist simultaneously.
Has there ever been a case in Kansas that you know of where someone was convicted of just taking?
Not that I'm aware of, no. And I will say that, there maybe 10 years since decision in Haberlin came down. So no, I'm not aware of that in that 10-year span of anyone who's been convicted, appealed, and then.
And let me just in Haberline, that really was not an issue. That what was described there as alternative means was dicta, as far as I can tell. That was not a part of the analysis in Haberline. The kidnapping was the question of whether it was a confinement or a taking was not an issue.
It was not before the court necessarily, no. The issue that was squarely before the court in that case was this idea that I think it was the commission of flight, and also then the other things those were argued at that point in time to be alternative means. At the same time, I don't think that it was, while yes, it wasn't necessary for the court to reach that, to solve the issue before it, resolve the issue before it, the court it wasn't dicta in the sense that it was sort of a offhand comment. It was in the course of analyzing that question, the court stated very clearly that these are alternative means, these other things are not. So there was some degree of analysis, whether cursory, I will say, but an analysis nonetheless.
If I want to transition you quickly, if you're right and we agree with you and Haberline says they're alternative means, what's your argument that there's insufficient evidence on both alternatives in this case?
So in this case, my argument is that the insufficient evidence, or the evidence was insufficient for a taking. Mr. Hayden in this case arrived voluntarily. At that point, he arrived voluntarily. My client was there. There's not a lot of evidence of exactly what he was necessarily doing at that point. Mr. Hayden went to the restroom, comes back. This is sort of a meth-fueled environment where they become suspicious that he's a police officer of some kind. Another individual.
And they take him into the bathroom?
Eventually. Now,
Isn't that a taking?
I would say that's not a taking because it's incidental to what actually was occurring, which was an aggravated battery. Really, this case it's such a difficult case because it's charged under felony murder, and really,
Well,
I think it's sort of
hypothetically, if by force or fear, you overcome someone and you move them from one room to another, why haven't you taken them?
in this particular case, the situation was that the Bailey, I think it was, struck Mr. Hayden in the head. He's been incapacitated, and the evidence was from that point that Bailey then instructed my client to remove him to the bathroom, not in furtherance of a taking, in furtherance of a kidnapping, but in the furtherance of There was some evidence that they were upset that he was bleeding on the couch. They were upset that he was making a mess, and it sounds terrible, but that's what the evidence was. So Bailey instructed my client at gunpoint, remove him, shut him up, is what he said. Get him into the bathroom and shut him up.
Well, that strikes me as going to the mens rea, not the actus rea. In other words, the intent to hold. But you don't,
True, true.
the sufficiency challenge has nothing to do with the intent to hold.
It has to do with the act.
Has to do with the act.
And
And
but I would
once you
say
knock
that
somebody
act,
unconscious and drag them into a different room, just seems to me.
right, but the question is, was that done through my client's volition, or was he ordered to do it at gunpoint? And the evidence here is that he was ordered to do this, not through his own will, but at gunpoint,
But
and
did the
not.
jury reject that?
But and in that circumstances, he was removed in order to continue beating him, not in order to hold him or remove just to take him somewhere. So it was done in furtherance not of a kidnapping. I don't think they had any interest of really to me, the way the facts came out in this case. It looks like it just took a long time for them to kill the poor man. Not that they were trying to kidnap him to hold him. So I guess that would be my response to you, you know. I don't know if there is any other questions for me at this point, but if not, I'd yield the remainder of my time. Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I'll take the argument and the issue that it appears in the brief, and I will just briefly address the instructional error, and then frankly move on. It was just a little bit unclear. I think we've had a little bit of clarification here today. The issue isn't really instructional error. We're talking about sufficiency, but to the extent there was any kind of an instructional error claim, the state does maintain, as asserted in its brief, that it was invited. So now we need to turn to the kidnapping statute itself and whether or not taking or confining are alternative means or options within a means. And ASA 215408 subsection A reads in plain language, kidnapping is the taking or confining of a person accomplished by force, threat, or deception with the intent to hold such person. And then we set forth the alternative means of kidnapping. The first thing that I would say, and I am urging this court to reach this issue as a preliminary matter, because if taking or confining are options within a means, then the defendant's argument is done, it fails. And also, if these only if these were alternative means, would we have to go on to the super sufficiency analysis? So we need the clarification. Here I would start by saying I do believe that what we have to look at here is whether or not taking or confining set forth distinct material elements. That's the language from Brown in 2012 that this court has offered us as the test to help determine whether or not things are alternative means, or whether or not they just describe a material element. The first thing I would say is to look at the structure of the statute. As Judge Malone pointed out, the structure strongly suggests in this case that taking or confining are options within a means, because it's all part of one sentence. It's all there together. The second thing I would say is, as was discussed a little bit here, it is almost impossible to come up with a hypothetical where there is a taking but not a confining, or a confining but not a taking. That should illustrate to this point, to this court, the problem that we have. The problem that we have here following Haberline. Respectfully, the state does assert that the quote in Haberline was dicta, and it was obiter dicta at that. It's not entitled to any weight. This court was clear that that question was not before it at all. There's little to no analysis, if any analysis, of whether or not taking or confining were truly alternative means in that case. Contrary to Haberline, then, I think we can start with Lloyd. And in that case, the majority even began by noting that both under the common law and under a statute, unless clearly modified, kidnapping means to take and carry away a person by unlawful force or fraud and against his or her will. That's been the law since 1957 in Kansas. Take and carry away, take and confine. These are the same thing. They have been the same thing for a very long time. Also, citing to burden from this court, the Lloyd majority even noted that under the kidnapping statute, it's well settled in Kansas that it is the fact, not the distance of a taking, or the fact, not the time or place of a confinement, that supplies the necessary element for a kidnapping. It's the restriction upon one's liberty to move about freely and lawfully. That is what constitutes a kidnapping, and that can be done taking or confining, because those words describe a factual scenario. There are options within a means. The majority went on in.
Can I just stop you
Sure.
there and clarify? You're saying they're descriptive because those two words encompass the universe of ways in which one's movement can be restricted. In other words, one's movement can be restricted by either being forced to go somewhere you don't want to go or being prevented from going somewhere you want to go. That strikes me as the modification to the elements from the old common law, which is carry away, take and carry away, as you said, versus take or confine.
And to be.
Take or confine is more broad, frankly, right? If you voluntarily walk into a room and I lock the door behind you, you haven't been carried away. But your
It is-
autonomy of movement has certainly been.
It's difficult to answer with certainty because have been taken out of your ability to move about freely in society, even just by being locked in a room. You're also confined. That's true. But if we understand carrying away is to physically carry someone away, I don't know.
I guess I wasn't trying to get into those weeds.
Yeah.
Just say, it struck me that your argument is, look, these are just descriptors because they describe the two ends, the two ways that a person's movement can be restricted.
And I think it's fair to say they are descriptive of how one's liberty can be taken, can be removed from them, to be taken and confined. Yes, they are descriptive of those scenarios. And I think the fact that they are descriptive is also highlighted by Lloyd, Gustin, the cases that are cited in the state's brief, where those two things they mean virtually the same thing. And that's the next point I wanted to mention is when we start talking about the dictionary definitions. Can look at them side by side and they clearly mean they're almost identical. I won't belabor that point here today, but I would simply suggest that this isn't just the state up here making this argument. This court should follow Judge Malone's reasoning and his concurrence in Lloyd, and just make it clear for both the state and defendants who have to make choices about how these cases are charged, how they're defended, whether or not these two clear options within a means need to be further confused in the future. The other thing I would say about definitions is that the real concern here has always been about, with these kinds of issues, it's always been about jury unanimity. And jurors we understand they apply common meaning, common understanding. A common juror is going to look at this and say, well, they're taken and confined. I mean, those things exist simultaneously. And I would finally note that if one has to work, again, if one has to work so hard to hypothesize about a scenario that may only exist in fiction or film, then that again should strongly suggest to this court that take or confine mean the exact same thing. That's not the correct focus. This court should actually, if we're going to say these are alternative means, then we should have to ask, are these two things almost always different, or are they mutually exclusive? And the answer to that question is no. With that said, if there are no other questions on whether or not these are options within a means which the state believes it's very obvious that they are, I will just briefly move on to the sufficiency. Here, the state believes that the evidence was absolutely sufficient, that there was a taking or confining, even if this court were to conclude or assume. But again, I'm urging this court to please do not assume that these are alternative means. But even if they were, the evidence here was sufficient. As to Justice Steele's question, taking the victim to the bathroom in this case, the state respectfully disagrees that that was an incidental movement for a couple of reasons. One, yes, there was some bleeding that was going on in the living room, but the others and everyone involved that was suspicious of the victim in this case, they blamed defendant for bringing him into this situation in the first place, and it was up to him to deal with this. This wasn't just to continue an aggravated battery. It was to take him to another place so that things could escalate, so that he was taken out of any ability to move freely about. I think it's also clear that alone could constitute a taking, because we had evidence here of what happened when someone came back to this drug-fueled suspicious den. They tripped over the body. It was right at the front door. So this wasn't just merely incidental. They're taking him further away to conceal what they are doing. This is not merely incidental. Beyond that, there is also indisputed evidence from the coroner that we don't know exactly when the victim in this case died. We don't know if it happened when he was beaten repeatedly while bound in the bathroom at the house and while laying in the bathtub and begging for his life, or if it was after the defendant had placed as many as 3 or more trash bags over his head. Then they wrap him in a blanket, stuff him in the trunk of his own car, drive him around town and abandon him in a defunct restaurant parking lot. We don't know when that happened. Taking the victim away in his trunk and leaving him somewhere where, frankly, no one's going to really be there. It was just happenstance that the defunct restaurant had a camera that showed the defendant parking the car there, again, would constitute a taking. And viewed in the light most favorable to the state, we can assume that the victim would have been alive at that point in time.
Take someone with an aggravated battery by hitting them over the head with a crowbar.
Could you also take them at the same time by just hitting them with a crowbar?
Are they mutually exclusive?
I don't think they're mutual. I don't think they are mutually exclusive. You would have to have some other. That would be by force. I would acknowledge that, but I don't know that it would constitute a taking. It certainly wouldn't be a taking in almost every case. I mean, I suppose this is, again, we
No, they really
hypothesize.
hit him over the head with a crowbar as he was
Right.
trying to leave.
Right.
Was that a taking?
I suppose it could have been. They were preventing him from trying to leave, and in doing so, the first hit, stumbles him down. But so maybe not the first hit, but the second, when they knock him unconscious to the floor, and then yeah, that probably could have been. It's pretty clear they wanted to make sure he could not move to leave, to be the police, or to snitch on them, for lack of a better phrase. Finally, as to the sufficiency of the evidence, I would also just point out, as I note in my brief, defendant himself in the second issue, and I understand they're different, but in the second issue, notes 2 instances of potential taking, and I don't think the court should overlook that in any way. Finally, I guess I would say, as just noted in my brief, even if for some reason that the the kidnapping were to fail, the felony murder should still stand here. I think if there are no other questions, I'll touch on, I'll just stand on my brief unless there are questions on the multiple acts, because I think that the record here itself is pretty clear. The court made a good record about why this was a constant series of acts, beginning from suspicion to dumping of the victim at the restaurant. All right, I see I have no other questions. I appreciate this court's time. We would simply ask that this court,
If I could, just since you have a little bit of time left.
Sure.
Can you clarify for me, because I got a little bit mixed up in looking at the record, but when they talk about the morning, the witness that testified, the one that went to the police, somebody said that this happened over a 12-hour period or it was overnight. But when they said she left in the morning, does that mean like 1 a.m. in the morning? Do you remember from the record the time span?
it was a little bit later than that. It would have probably been, my best recollection, it would have been probably 4 or 5 hours, because it was around the midnight time. And then we have the video showing the victim in the trunk appearing at the defunct restaurant sometime around 6 or 7 in the morning.
It was, okay.
And then that person reported to the police yet later that
Right,
night. Yeah.
right, okay. So, because when I first was reading it, I was saying in the morning she went to go run errands. And so I'm thinking, oh, it's 7 o'clock in the morning. But then, no, she was running errands at,
It was in the early morning hours. They ran
Right.
out to do something
okay,
and stopped at a
errands.
quick trip. It was
Okay.
errands.
Okay, errands, but it was like more of like the middle of the night. Okay, thank you.
If there are no other questions, I really appreciate this court's time and respectfully request that the defendant's convictions be upheld in this case. Thank you very much.
I want to address a couple of things with my rebuttal time today. First of all, I would like to say that this statement that it's the fact, not the distance, that matters in kidnapping. That's absolutely true under burden, but that is not the full story, because if you look at the case that I cited, Kemp, which relies on bugs, unless there's some other crime going on, then it can become incidental. For instance, if somebody's removed from the front of the store to the back of the store to get a key, that's not kidnapping. It was incidental to the robbery. So my argument here is that when he's taken from from that living room to the bathroom under orders to do so by Mr. Bailey, that's incidental to the aggravated battery. Furthermore, this question of what Mr. Hayden's condition was at that point. He'd been struck twice in the head with a crowbar, according to the evidence. The witness that came returned to find him on the floor said he was, his face looked like hamburger. There's no question that this was furtherance of continuing an aggravated battery. The other question.
What about the argument that then the taking, or the argument the jury could have found it taking from the removal from the residence to the parking lot?
I know
Maybe
the
you're
coroner,
getting to that, sorry.
No, it's fine. I know the coroner wasn't able to definitively give a time of death. However, Mr. Delgado, the accomplice with testimony in this, was that they were sure that he was dead. That he was struggling for his life until the point that they placed bags over this man's head and strangled him. The coroner's testimony was that his cause of death was asphyxiation. So I don't think there's really any question that at that point when he was removed from the residence, that's not a taking because he was no longer alive. Lastly, when you'd asked Justice about is that a taking when you strike somebody in the head with the crowbar? And I would submit that it depends what your intent is. If you're wanting to use that as taking, I'd say it depends what what the actor's intent is if their intent is to hold them, and that's in furtherance of that means of taking, then I think yes. But in this case, I think all the evidence was Mr. Bailey just all of a sudden decided to hit this man in the head with the crowbar. At that point, everything it's just chaos. As my colleague described it as just a meth den. So I just wanted to address that. And I see my time is up now. I thank the court for its time this morning, and I'd ask for a reversal of Mr. Garcia-Martinez's conviction.
Thank you to both counsel for your arguments today. The court will take this appeal under advisement.